Welcome back to day 2 of the conference on fairness, accountability, and transparency. I'm Solon Brokus, General Chair this year. It's nice to see many familiar faces from yesterday, some new faces today. We had allocated some time this morning for some announcements, and it turns out that we don't have too much to announce, so we let the morning breakfast go a little long. But the main announcement to make is that we are happy to say that we'll have another conference next year. So we have a steering committee for the conference, and we met last night and discussed certain matters regarding the future of the conference and how to ensure its health and sustainability. And we can say that we'll have a conference next year, and it will be likely around the same time, a couple of days earlier, a couple of days later, depending on the venue. And perhaps unlike this past year, there'll be a much longer lead-in time to the deadline. So we'll have a paper deadline submission sort of in the beginning of the fall, and then the conference itself, again, will take place around this time next year. There's no plan yet exactly where it will take place, but we'll be able to have that news shortly. And we hope that you'll all consider submitting papers. I want to emphasize one particular point. So as I mentioned yesterday, the conference in part grows out of the workshop on fairness, accountability, and transparency in machine learning. But our goal here is really to be broader than machine learning. So the program, in a way, reflects that particular history. There's a pretty strong representation from machine learning in particular. But our hope is that we'll have a more diverse and more balanced set of presentations and papers. So please feel that if you are someone who is maybe not from machine learning, that this conference is also for you, and that our goal is to really broaden this as well. And with that, I'm now just happy to introduce our second keynote speaker. So that is Deborah Hellman, who is the David Lurton Massee Junior Professor of Law and the Roy L. and Rosamond Woodruff Morgan Professor of Law. Deborah is really a kind of crucial figure in the field of legal scholarship, and in particular of legal philosophy, around questions to do with discrimination and equality. She's done seminal work really bridging normative theories to help explain, as we'll hear, why discrimination is wrong to the way that the law has thought about questions of discrimination. Deborah was a very obvious choice for a keynote for the conference, I thought, because she's done really crucial work drawing out the reasons for the normative reasons why we might want to think and care about discrimination. And I think, as has kind of come up this past day, this is really something that this community needs to think more deeply about. So the presentation today will really tackle this head on. We'll hear this kind of basic question about when is discrimination wrong and why. And so it really gives me great pleasure to be able to invite up Deborah, and we'll follow the same format as yesterday, where we'll then have some conversations afterwards. So thanks so much, Deborah.
Thank you. Actually, just moving this over so I have room for my notes. Actually, I should have done that before. So first, thank you to Solon for inviting me. I'm highly flattered to be here, and to Cynthia, who's going to be my interlocutor, for introducing me to this community. It's very exciting for me, and I'm happy to be here. So my talk is on what is discrimination, when is it wrong, and why. I'm going to look at the question as a philosophical matter rather than as a legal matter, but if you have any questions in the Q&A about legal questions, I'm happy to answer them. So the conference title is Fairness, Accountability, and Transparency. So another way of putting the question I'm interested in is to say, when is it unfair to distinguish among people and treat them differently as a result, and why? So let me start with a story. There's a famous philosophy professor by the name of Sidney Morgenbesser from Columbia, and there are tons of great stories about him, but I'm just going to tell you one that I think is appropriate and useful for our inquiry. Morgenbesser was called for jury duty in the 1980s in a case dealing with police brutality. And during the voir dire is where the judge asks the prospective jurors various questions. During the voir dire, the judge asked all the prospective jurors, because the case was dealing with police brutality, has anyone ever been treated unjustly or unfairly by the police? So Morgenbesser raises his hand, and when the judge gets to him, Morgenbesser says, well, I've been treated unjustly, but not unfairly. You can imagine the judge's reaction. But the judge asks the philosopher to explain, and he says, well, I was participating in the sit-ins of Columbia University in the late 60s, early 70s, and I was sitting in at the president's office, and the police came and they beat me up. And that was unjust because I wasn't resisting arrest, I would have come with them, it was a political protest, but it wasn't unfair because they beat everyone else up too. Okay. There's my friend, Sidney Morgenbesser, when he was young. So Morgenbesser's story makes 2 points, both of which I think are of interest to us. First, that there's a difference between justice and fairness. Everyone has a right, grounded in justice, not to be mistreated by the police. This right is distinct from a concern with fairness. If the police only beat up men but not women, or black people but not white people, we would say that both justice and fairness were violated. But no one should be beat up, the injustice, and the policy should not distinguish between people in an unfair way. That's the fairness question. The question we're interested in here today is the fairness question. So the first point I want to make is it's important to distinguish between those, between questions of justice and questions of fairness. Another way to see this is imagine that you're using one of your fancy algorithms to decide who should get health insurance at community rates and who should be charged higher rates. This procedure could be unfair. It might distinguish between people in a way that you think is unfair, and we'll unpack and say a little bit more about that, what that might entail in a minute. But it also could be unjust. If you're like me and you think that everyone has a right to health insurance, then there's an injustice going on in some people not getting it at a reasonable rate, regardless of what the fairness issue might be involved in, regardless of whatever sorting procedure is used. We want to focus, as I said, on the fairness question. Second point that's useful for us is the story contains an assertion about what satisfies fairness. Morgenbesser's answer to the question is treat everyone the same. If everyone is treated the same, beaten up, there's no unfairness, Morgenbesser asserts. This claim could be stated in 2 different forms. One version, same treatment is necessary for fairness, or alternatively, same treatment is sufficient for fairness. Let's consider them each in turn. First, take the first one. Does fairness require that everyone be treated the same? This view is clearly implausible. Laws, policies, practices routinely distinguish among people on all sorts of bases, yet most of us think, and rightly so, that many of these instances of differential treatment are perfectly permissible. Consider the following example. This is my daughter, Juliana. This is when she's getting her driver's permit, her learner's permit. Just as a matter of aside, she's actually taking her driver's license test today, so you can feel for me. Go, Juliana, exactly. Okay, so in many states, one must be 16 to drive. Actually, it's a little varied, but we'll just pretend that it's 16. This law treats people who are 16 and older differently than people who are under 16. Or another example, one must pass the bar to practice law. That law differentiates between bar passers and non-bar passers in terms of who gets to practice law. Both of those policies, the driving age example and the bar passage example, draw distinctions among people and treat people differently as a result, and I think most of us think that's perfectly fine. So let's take the weaker form. Maybe same treatment is sufficient for fairness. If everyone is treated the same, surely that's enough for the policy to be fair, one might think. This question makes me think of Anatole France's famous quip, the law in its majestic equality, forbids rich and poor alike to sleep under bridges, to beg in the streets, and to steal bread. Policies that formally treat everyone the same, no one may sleep under the bridge, affect people in different ways. And sometimes we're worried about that too. So what does fairness or avoiding wrongful discrimination actually require? In the first part of my talk, I'm going to describe some of the views, some of the possible answers that different people give to this question. I'll present each of them as a hypothesis and sketch something, a little bit about what's appealing about that view and what's problematic about that view. In the second part of the talk, I'll turn from describing philosophical views to offering an argument that I hope you'll find interesting and relevant to the kinds of work you do. So the first hypothesis one might have is that like cases should be treated alike. While we can't treat everyone the same, at least what we ought to do is treat like cases alike. This idea obviously taps into an intuitive idea about fairness. I have twin godsons. Now they're 20, but when they were small, I used to babysit for them. Suppose I said, their names are Will and Jack. Suppose I said, Jack, you have to go to bed at 8. Will, you can stay up till 9. The immediate reaction would be, that's not fair. In so saying, they're asserting that because they are alike, they're twins after all, they should be treated alike, same bedtime. But in fact, this understanding of fairness is not so easy to defend. The first problem is that people are like and unlike one another in an infinite number of ways. So how do we know which similarities matter? Suppose I answered Will's complaint by saying the following. You boys aren't alike. Jack is wearing a red shirt and Will is wearing a blue one. That response would clearly be unsatisfactory. Jack would likely say, that doesn't matter. In other words, we're judging likeness and unlikeness relative to something. But to what? I might say instead, Jack, you're sick and Will is not. Or, Jack, you misbehaved earlier and Will did not. Whether either of those responses will be satisfactory depends on what we suppose the purpose of the bedtime rule is. Is the purpose of the bedtime rule to make sure that each boy gets adequate sleep? Or is it used to punish bad behavior? Or something else? We can only know whether the cases are like or unlike in relation to a purpose. On this theory, unfairness is a form of irrationality. A policy or practice is unfair if it treats cases which are alike with regard to the purpose or of the practice or rule differently. But even this is somewhat of an overstatement. Let's return to my driving example. The rule is you have to be 16 to drive. This rule discriminates on the basis of age. If you're 15 and younger, you can't get a driver's license. If you're 16 and older, you can. Obviously, in most states, there's a test as well, but I'm simplifying here. Does that rule treat like cases alike? Well, that depends, as I've been stressing, on the purpose of the rule. Let's suppose, quite plausibly, that the purpose of the age restriction is to only license drivers with the skill and maturity to drive safely. Age is probably a reasonably good proxy for skill and maturity, but of course, not a perfect proxy. It will be both over and under inclusive. So in fact, likes, with regard to the traits of skill and maturity, are rarely treated exactly alike. Some 15-year-olds will have as much skill and maturity as some 17-year-olds, yet the first can't get licenses and the second group can. So call the degree of over and under inclusiveness between the proxy trait, age, and the target trait, skill and maturity, the fit. On this view, then, wrongful discrimination or unfairness occurs when the fit between the proxy trait and the target trait is too loose. Okay, so that's describing the view. There are some problems with the view, now that we've refined it. The first is that lots of what we generally think of as wrongful discrimination has a pretty good fit. That is, doesn't have the ill fit that we just described. This is a boring slide, sorry about that. Race or sex sometimes is a good proxy for a legitimately desired trait. In a canonical sex discrimination case from the Supreme Court called Frontiero v. Richardson, which is from 1973, the Supreme Court invalidated a policy by which the military used sex as a proxy for having a dependent spouse. So if you were a male service member, married male service member, the military presumed you had a dependent spouse and gave you spousal benefits. If you were a female married service member, you could still get the spousal benefits if you proved your spouse was dependent on you, but there was no presumption. This was obviously a benefit for male service members because even if they had a non-dependent spouse, they still got the benefits, whereas the women did not. Does this policy treat like cases alike? Well, if sex is a reasonably good proxy for having a dependent spouse, then like cases are treated alike. And in the 1970s, it probably was a reasonably good proxy for having a dependent spouse. Okay, so maybe we should modify the view and instead propose that irrationality is sufficient but not necessary for wrongfulness. There might be something else unfair about inaccurate classifications, but ill fit between proxy and target is unfair too. So you could say about my Frontiero case, yeah, it doesn't have that problem, maybe it has another problem, but still insist that when there is ill fit, there's some kind of unfairness. So let me give you another example to challenge that hypothesis. Suppose an employer believes that smart people wear glasses, and so gives a bump in applicants to applicants who wear glasses. Suppose also that she's wrong. There's no correlation between wearing glasses and intelligence. And so cases that are reasonably alike are not treated alike. Sue, an applicant who doesn't wear glasses, is not hired. Does she have any complaint? What would it be exactly? She might say she has a right or entitlement to be assessed by criteria that really are relevant to the purpose at issue, to the job or, being smart. But why? An employer has an incentive for sure to use rational search criteria, but if the employer fails to do so and makes a dumb choice, like my employer, what right of the applicant is violated exactly? The applicant says, but I have the skills that you really need. So what? If the employer doesn't see it, too bad, it's his loss. Well, you might say it would be better for society if everyone used rational search criteria or rational sorting criteria, if they efficiently chose the best employees. This answer has more going for it from a moral point of view. It has some moral oomph to it, but it too fails. It's unclear why, first I'd say it's unclear why an individual has an entitlement, because after all, Sue is the one complaining, to what's good for society. But even if the answer has something to it, if efficiency is what matters, it should be judged in the aggregate. Consider the following example, and this is from the philosopher Norm Daniels. Suppose Jack and Jill both want jobs A and B, and each much prefers A to B. Jill can do either A or B better than Jack. But the situation S, in which Jill performs B and Jack A, is more productive than Jack doing B and Jill A, S prime, even when we include the effects on productivity of Jill's lower satisfaction. If efficiency concerns require hiring procedures, they would at most operate at the aggregate level and tell us choose the most productive assignments of people in the aggregate. It would not give Jill, who's the most skilled, an entitlement to the job that she wants because she's the most productive at it, because that assignment might not be most efficient for society. So irrational job criteria, like my glasses example or anything else, are dumb, but we don't have an individual entitlement to be judged by efficient criteria. Now, I hope this is okay. I don't want to put anybody on the spot, but I picked this out from a New York Times op-ed piece on December 20th, 2017. Actually, my colleague showed it to me, just to show you how this claim that I'm arguing against is out there. So I'm just going to read this passage. The second way, this is, you can see whose paper it is, and I apologize if I'm using someone unfairly. But the second way in which bias can enter the data is through risk factors that are not equally predictive across groups. For example, relative to men with similar criminal histories, women are significantly less likely to commit future violent acts. Consequently, algorithms that inappropriately combine data for all defendants overstate the recidivism risk for women, which can lead to unjustly harsh detention decisions. Is it unjust? Unfair? So what would be the justice claim? What's the claim? That you have a right to be judged by criteria that are really predictive, or that we know are predictive. So the first states it in a fact-relative sense that really are predictive. The second states it in an evidence-relative sense that we know are predictive. Why would that be? Suppose that we had, it turns out that brunettes are, there's a difference between brunettes and blondes in terms of their, so that the criteria overstates it with regard to brunettes as compared to blondes. I'm not sure we'd say that, or glasses, to use my example, would we see the same sort of statement if it turned out that people who wear glasses are less likely to recidivate than others? But that hasn't been included. Would we say that glasses wearers are treated unjustly? I think the focus on women is what suggests the unfairness rather than the inaccuracy. That is, if there's any unfairness, it has its home somewhere else. Maybe the thought is that this difference between the recidivism rates would have been attended to if it were not for the fact that who it benefits is women and their interests aren't given adequate consideration or something like that. But that concern is not a concern about the inaccuracy, it's a concern about differential sympathy or something along those lines. Which brings me to my second hypothesis. And I'll have more to say about the first one in my second part of the paper in case you're interested in it. So my second hypothesis for unfairness is it's the thought that counts. That is, maybe what matters to whether a policy or practice is adopted for bad reasons, maybe what matters is whether a policy is adopted for bad reasons, and especially in order to keep certain people, women, racial minorities, the disabled, what have you, from opportunities, jobs, places at school, loans, etc. On this view, drawing distinctions among people is wrong when it's done in order to keep people out or down, but when it's done with that intention or purpose. What does this view have going for it? It too taps a pretty basic intuition that hatred, animus, or plain spite are problematic motives. Why? If you think about why we're worried about laws, policies, and practices that differentiate between people in the first instance, we're worried about it out of a moral concern that people matter equally, that people are equally important from a moral point of view. Yet, if a policy or practice is adopted out of ill will or hatred, it seems to deny the basic moral claim that animates our concern in the first instance. So if a person acts purely in order to keep some people from getting a benefit and for no other reason, that seems morally troubling. Okay, but so much of what, again, this doesn't fit our intuitions about real cases, so much of what we find objectionable doesn't fit this description. Most instances of unfair treatment or wrongful discrimination lack this sort of animus. So here's an example. Suppose an employer is less likely to hire, gives some demotion in points or something to women who are between the ages of 25 and 40 because they're more likely to take time off to care for kids. The policy is not adopted in order to keep women out of the workplace, it's adopted for reasons of productivity. This example, and so it seems like it satisfies the criterion of being well motivated, yet seems clearly morally troubling. This example highlights an ambiguity about what we might mean when we say it's the intention of the actor that matters. The employer's using an explicit sex-based classification, so maybe you think it does have a bad intention because the sex-based classification is right there in the policy. So are we focusing on whether there's an explicit sex or race or whatever trait classification in the policy, Or are we focusing on the reason for which such classification is adopted? Which brings me to my third possibility, which goes by the name of anti-classification. Maybe what's problematic is classifications. Now this view, as I said, is called anti-classification, but that term is actually highly misleading. As we noted at the start, you can't avoid classification altogether. Rather, on this view, the use of certain classifications is prohibited: race, sex, and other protected traits. But why? It's not at all obvious, without saying more, why there's something morally troubling about using particular traits to distinguish among people. Well, it's not impossible to hold the view that there's just something in itself wrong about using race or sex or whatever the traits you want to put on the list, but not something morally troubling about using age, grades, whatever other traits you think are permissible. It seems to require some explanation, because after all, they're all just traits about us. They're kind of inert. They have no significance. They're just traits about us. So it seems to demand that we have some other explanation, otherwise it seems unmotivated. So I think the answer must draw on another theory. So here are some possibilities. There's a distinction between race and sex, and on the one hand, and other kinds of traits on the other, because the protected traits usually are not rationally related to legitimate purposes. That was hypothesis one, and we already talked about its pros and cons, and it has some significant cons. Or they're usually adopted for bad reasons. That was hypothesis two, about it's the thought that counts, but that too doesn't track our intuitions about most cases. So what else? Maybe they usually produce bad effects. Well, that's a theory we're going to turn to in a minute. Or they usually express denigration. Again, that's another theory I'll turn to in a minute. Maybe there's something else. I don't mean this to be an exhaustive list. I just think the view that certain classifications just are prohibited calls for a further explanation. So let's turn to the bad effects theory. Maybe distinguishing among people and treating people differently as a result is unfair because people are harmed. This view has moral appeal. All of them have something morally appealing. I hope you're getting that recurring theme. This view has moral appeal because harm to others is clearly bad. But it also has problems. Which harms matter and why? Most policies that distinguish among people and treat people differently disadvantage some people relative to others. And most of the time, that's perfectly acceptable. Using high school grades to determine admissions to college disadvantages students with poor grades who are denied admission at the college they seek to enter. Using standardized test scores disadvantages those with low test scores as a group, and possibly racial minorities as a group. Which effects matter and why? So this theory calls on us to decide or to add something about why certain bad effects are morally troubling, or certain effects on certain groups are morally troubling, whereas the same effects on other groups are not. So we need to fill that in with another theory, and I'm going to talk about two: entrenching caste and compounding injustice. Those aren't the only possible two. They're just two that I find particularly intriguing. The compounding injustice view is the one I advocate myself, but the other one I think is highly interesting. It's the theory of the entrenching caste view of Tarun Kaitan, who's a philosopher at Oxford. That's his recent book. It's a fabulous book. I recommend it to you. Okay, so let's take entrenching caste first. So according to Kaitan, severe and pervasive group disadvantage matters because it makes it hard for individual members of those groups to have access to basic goods like security and self-respect, without which they are unable to actually have freedom in the world. So it's grounded in the idea that each individual is entitled to freedom, and talks about how pervasive group disadvantage impacts individual freedom. It's a nice theory. Okay, now compounding injustice. This is the view I am attracted to. Perhaps there's a general duty that individuals have not to compound injustice. If there's been an injustice that happens, that's out there, people might have a moral duty not to carry that injustice into another realm and compound it in the sense of build on the prior injustice by making it worse, by transforming it into another realm. So that's the link if you want to read the paper where I put forward this view. It's on SSRN and coming out as a book chapter. So consider the following example. Suppose a life insurance company denies insurance coverage or charges higher rates to domestic abuse victims, as people who are being beaten up by their husbands or boyfriends or their partners are more likely to be killed during the policy period. In my view, this is morally troubling. Why? The abuse victim is already a victim of injustice, the assault, and when the insurance company uses that fact to determine her rates, it compounds that injustice by carrying it forward into another realm. Now it affects her ability to get life insurance. So the insurer has the obligation not to make the prior injustice worse by making it relevant in this new domain. Another example, suppose victims of child abuse are more likely to recidivate, if they go on to commit some sort of crime themselves, this makes them more likely to recidivate. That too seems like an instance of compounding injustice. The reason the person's more likely to recidivate is they're been a victim of a child abuse, and you are carrying that injustice and making it relevant in another field or another domain if you use that mechanism. So for similar reasons, I think sorting mechanisms that disadvantage racial groups may well compound injustice. But you might be thinking, not all members of racial minorities are victims of injustice, and so an action that produces a disparate impact on such groups may only compound injustice as to the members of these groups, but not as to some members of these groups, but not as to all. And that's true enough. But the same is true for the two examples I started with. A person who's classified as having been a victim of child abuse might not really be a victim of child abuse. Maybe the person lied because he thought it would help his case. In all instances, we're dealing with predictions or approximations. The strength of the argument that one should avoid disparate impact on racial groups because the action will compound injustice will depend on the likelihood that one will really compound injustice, but the fact that it won't happen in every case is not disqualifying. Okay, there are worries about, so those were two, the entrench caste and compound injustice are two theories that fill out the bad effects view, but there are worries about the bad effects view as well. Many policies entrench disadvantage of previously disadvantaged groups. Perhaps it's the role of government and not private actors to rectify these wrongs. When we say that private actors may not take actions that are otherwise rational for them to take because their actions entrench disadvantage, do we unfairly impose these burdens on certain actors that should be shared by society more generally? Just as an aside, my argument about the duty to avoid compounding injustice is meant to answer that problem, and you can judge for yourself whether you think it does. Okay, hypothesis 5, expressing denigration. Actually, I didn't have, well, I'll click the slide now too. Sometimes classifying on some grounds expresses something problematic about a person or group. Sometimes what it expresses is that one person or group is of lesser moral status. And maybe we have obligations to avoid expressing denigration. And I'll just say, this is the view I actually argued for in a book I wrote called When is Discrimination Wrong from 2008. I don't have the book cover for you here, though. So the appeal of this view. Well, if you think about why is it bad to say, give someone the finger, the middle one? What's bad about it, I just thought I'd clarify, is that it expresses denigration. If you're expressing something insulting or denigrating to someone, and if you're a person or an entity with power, that gives you a particularly strong reason not to give someone the finger or the equivalent. But we're talking in this whole conference about classification, not vulgar gestures. So how do certain classifications express denigration? I shouldn't have put the slide up yet because you're all reading it now, and I'm sorry about that. Notice that the finger, giving someone the finger, has meaning because of context and culture. In different cultures, different gestures are insulting. It's very dependent on the culture that you're operating in. So too, the use of racial classifications carries a meaning that other classifications do not, given our particular history and culture. So, for example, a rule that says all teens to the back of the bus doesn't express anything denigrating about teens. Teens love to sit on the back of the bus. That's associated with the cool spot that the teens hang out. Whereas the rule all blacks to the back of the bus expresses something highly denigrating because of the particular context and culture in which we live. The use of the same traits in some contexts, the use of some traits in some contexts expresses that the group is second class in this way, and I would say that's true about the racial separation there. This occurs regardless of the intentions of the person adopting the policy. So this view captures something about what was so awful about Jim Crow segregation. You see this view expressed in a lot of the cases. So in Justice Harlan's famous dissent in Plessy versus Ferguson, which was the case that said separate but equal was okay, from a long time ago. I have the Harlan quote up there. He describes the separate but equal regime as a law that is practically a brand of servitude, a degradation upon a large class of our fellow citizens. That, as all will admit, is the real meaning of such legislation as when it's enacted in Louisiana. So for Justice Harlan, what's wrong with the racial segregation, the separate but equal regime, is that it expresses denigration. If the regime was teens in the back of the bus, that wouldn't have that expressive meaning. What makes racial segregation in rail cars problematic for Harlan is that it is a brand of servitude and degradation. Okay, problems with this view. All the views have problems. You'll see the recurring theme. Maybe it only reaches the most extreme cases. Maybe only things like racial segregation and the elaborate system that accompanied it have such a clear meaning. About other kinds of classificatory regimes, their meaning might be far less clear, and people are likely to disagree about what the meaning is. So there's so much more I could say. This list of my 5 hypotheses is certainly not exhaustive of the different theories out there with regard to what makes discrimination wrong. I just wanted to give you a flavor. The upshot is there's no simple answer to the question, what is discrimination? When is it wrong and why? Okay, now I'm going to turn to, as I said in the second part of the talk, I'm going to give you an argument for a claim that I hope is of interest to you. So, part 2, is like cases alike an empty idea? Okay, so let's return to the idea that one should treat like cases alike. I'm going to call this the TLA principle, treat likes alike for short. We noted earlier that the maxim tells you nothing about which cases are like and unalike, and so must be supplemented by an articulation of the purpose of the rule. Because people are both like and unlike each other in an infinite number of ways, we cannot know which cases are like until we specify which differences and similarities matter and why. But once we do that, say which differences and similarities matter and why, oh my God, I only have 5 minutes? I've been talking way too slow. Okay, I'm gonna speed it up a little bit. The TLA maxim ceases to do any real work. Suppose person A and person B are both convicted of armed robbery, and a judge must determine their sentence. Are they like or unlike each other? Depends on the purpose of punishment. If punishment is to give people what they deserve, then it depends on what punishment each person deserves, and one's theory about what factors affect desert. But once we specify whether they're like or unlike each other, given the purpose of desert and the idea that we want to, and our theory about what factors are relevant to that, then we determined what punishment each person actually deserves. So the TLA principle is doing no real work. This is a point famously made by Peter Weston in an article from the early 80s. So Weston says, the article's called The Empty Idea of Equality. Thus, to say that people who are morally alike in a certain respect should be treated alike means that they should be treated in accord with the moral rule by which they are determined to be alike. Hence, like should be treated alike means that people for whom certain treatment is prescribed by a standard should all be given the treatment prescribed by the standard. Or more simply, people who by a rule should be treated alike should, by the rule, be treated alike. So there it is. Equality is entirely circular. So let me give you another example and then play with it a little bit. So A who deserves a sentence of 3 years gets 3 years. A judge is tasked with sentencing B. B also deserves a sentence of 3 years. Suppose the judge gives B 5 years. The problem, according to Weston, is not that likes are not treated alike. The problem is that B gets a harsher sentence than he deserves. In Morgenbesser's terms, it's a problem of justice, not fairness. Weston would say rights, not equality, but that's tapping the same idea. Admittedly, the TLA principle might help us see or identify the rights violation, but it does no moral work on its own. Now, Weston's argument has been criticized, and rightly so in my mind, because it purports to show the TLA is empty. And in that case that I just gave you, it was. But equality or fairness does do real work in a different sort of case. For example, A, who deserves 3 years, is sentenced to 1 year. The judge tasked with sentencing B is tasked with sentencing B, who also deserves 3 years. Here, the TLA maxim has force. It tells us to depart from the correct sentence and give B a lighter sentence than he deserves. So the thing to note about this is that the TLA does real work, but it tells you to repeat errors, not to get things right. Now, this example is unlike the kinds of examples you guys face, in that it doesn't involve prediction. The sentence is backward-looking to desert rather than forward-looking to dangerousness or something else. And there was a clear independent criterion of right or justice in play. In many of the examples you all work with, neither of those conditions apply. So let me give you another example. Suppose the state of New York wants to license all and only those drivers with the skill and maturity to drive safely. Of course, New York can't do that perfectly, so we might say New York wants to do that with a reasonable degree of predictive accuracy. I don't know, 85%. I'm just making these numbers up. Well, I'm sure you guys could come up with some fancy algorithm for this. I'm just going to use two traits for simplicity. Age, you have to be 16 to drive, and test passage. You have to pass the driving test, which includes a written and a driving component, because that's what they usually do. Now suppose there are two groups of people that we're comparing the results with regard to. Native English speakers in Group A and non-native English speakers in Group B. Suppose, not unreasonably, that for non-native English speakers, the test is a less good indicator of what we really care about, having the skill and maturity to drive safely. So the TLA seems to do work when we compare the accuracy of the tests for Group A and B. They aren't equally accurate. But taking a page from Weston, we can see that the problem isn't really that we're not treating likes alike. Instead, the problem is that for Group B, we're not complying with the rule we adopted, that is, that we wanted to have 85% predictive accuracy. We're failing to license too many drivers with the skill and maturity to drive safely, simply because they have poor English. The TLA helps us see that, but it isn't what's morally wrong. Wait, you might be thinking, we may not know in advance what degree of predictive accuracy is the right standard to apply, and the TLA helps us because it tells us at least treat like cases alike when we don't know what standard to apply. So Kent Greenewalt, who critiques Weston, makes exactly this point if you want to read that paper. So the TLA does some work where there's indeterminacy about the correct standard to apply, and of course the TLA does real work in the cases of error. in the group of non-English speakers, it turns out really you have to have three traits: age, test passage, and a good ability to learn new things, or something like that, in order to get licensed. The TLA would tell us we should impose a similar burden on English speakers. Now, I'm not advocating that we do this. The point is to recognize when the TLA has real bite, when there is uncertainty about the standard of likeness and with regard to how we handle errors. Now, I was going to talk for 5 more minutes about, or should I end? Okay, I'll try to be quick. So I want to make the same, I want to make the same point in a different way just to hammer it home. That is that inaccuracy is not unfair. I'll try to talk quickly, but this doesn't mean that inaccuracy never matters morally. Sometimes it does, and I'll say a bit about when and why in a minute, but when it does, the moral issue doesn't have its home in a concern with fairness or non-discrimination. In order to make this point, I want to introduce another distinction. Philosophers love distinctions, and that's between comparative and non-comparative claims. If a person asserts a non-comparative claim, she's saying, I've been treated less well than I'm entitled to be treated, regardless of how anyone else is treated. That's Morgan Besser's I've been beaten up. It's wrong even if everyone else is too. A person asserts a comparative claim when she says, given that you gave person A treatment X, you should give person B treatment Y. This can be a demand for equal treatment. The child who says, Sue got a piece of cake, I should get one too. But it doesn't need to be. For example, in any time that you have a grade curve, for example, that says that given that I gave exam number 1 with a raw score of X, a grade of B+, I should get exam number 2, which has a slightly higher raw score, an A-, and so on. That's a comparative claim without being grounded in equal treatment. So fairness is a comparative notion. Given how X was treated, how should Y be treated? Morgan Besser uses the term justice to capture the non-comparative notion, but there's nothing magic about the terms. It's the ideas that matter. So there's the non-comparative idea and the comparative idea. Has a person been treated as she ought to be treated? That's the non-comparative idea. You could call that justice, non-comparative justice, rights, or there's the given how person X was treated, how should person Y be treated, a real or hypothetical other. That's the fairness idea, or comparative justice or equality. My claim is that accuracy is a non-comparative notion, and so not really a fairness concern. I'll just say one tiny little thing about it. How do you tell whether something's a fairness notion, a comparative notion, or a non-comparative notion? The standard answer is you level down. You beat everyone else up and see if you've still got a problem. If it's a fairness problem, when you level down, there's no fairness problem, but there's still if it's a justice problem, when you level down, you've still got a problem. So let's imagine that we treat everybody inaccurately, because we're trying to decide if accuracy is a fairness notion, a comparative notion, or a non-comparative notion. So if we treat everyone with an inaccurate procedure, a highly inaccurate procedure, is that unfair? My intuition, which maybe you don't share, is that that's not unfair, that in fact lotteries or drawing of straws, which are inaccurate procedures for selecting people with traits, are the quintessential examples of fairness, of fair selection procedures. Now if there's, and this is where I really will end, if you think that there's something wrong with maybe I won't. If you think there's still something wrong with it, maybe there's something wrong with inaccurate procedures that's bothering you, has its home somewhere else. Remember at the beginning I said we have to make sure we're not tapping into something else. So if a state draws straws to decide what sentences people should get, the problem isn't a lack of fairness. The problem is you're not complying with the underlying requirement that punishment track desert. That's the justice standard. Or if I throw the exams down the stairs, the problem is, and assign grades that way, the problem is that I have some obligations coming from my role as a professor to grade the exams in a different manner rather than a lack of fairness. Or if I use an inaccurate risk assessment tool to decide who to civilly commit because they might pose a danger to others, say be a school shooter, for example, the accuracy matters not as a matter of fairness, but because there are third-party interests at stake, who, the teenagers in schools, et cetera. So sometimes there are reasons for caring about accuracy, but they have their home somewhere else. Now, some actors might have special obligations to care about accuracy, you might think. It's one thing for a private employer to use inaccurate classifications, but not a public employer. A public employer you might think has special obligations. So I just want to point out, though, that sometimes actually it's the opposite, that the government employer has special reasons for treating us the same, even when that's inaccurate. Think about airport screening. It's certainly plausible that rather than make each of us go through the screening, they could develop a highly efficient profile that would sort people better. Now, they probably use some profile, but still we all have to go through those screenings. And perhaps they could improve their accuracy. But why do they make us all go through the screenings? I think they do it because by imposing the burden on all of us, despite the lack of classificatory accuracy, they thereby express that we all matter equally and must share equally in the cost of avoiding terrorism. In other words, sometimes fairness requires that different cases be treated alike. And I really am going to not do the last thing, which is the application, and end here. Okay. Sorry, I must have done it slower than I did it at home.
Thanks so much. It really pains me to have to end earlier. This was fantastic, Deborah. Thank you so much. And I'm not going to spend as much time as necessary to introduce Cynthia Dwork, who I'm sure everyone in this room must know. Cynthia has kindly agreed to act as a discussant with Deborah, so I'll invite her up right now. She's a professor of Harvard in computer science who's done seminal work in cryptography and many other fields and has recently done work on fairness. And frankly, this is a highlight for me of the conference, so I'm really looking forward to this.
Solon, how much time do we have? And
Sorry about going over.
can you flag me at 5 in 10 minutes? All right. So, first of all, thank you very much, organizers, for inviting Deborah Hellman, and giving me the opportunity to have a discussion with Deborah. Over the last couple of days, we've been exchanging email and thinking quite a lot, and it's been tremendous for me. I hope that some of the rest of you can get something out of this response as well. So first of all, I thought the presentation was brilliant, and I think that this kind of disentangling of feelings and thoughts to try to understand why we feel a certain way is extremely important, and I love the work that you've done, and the field, I think, needs more of it. I particularly enjoyed the Morgan Besser vignette, and this idea of separating fairness and justice, of course, it resonates very strongly for me. I had prepared a lot of things. I started with a list of 4 things, and it grew to 11. But why don't we start for a moment with randomness? Because you just touched on it at the end. And you gave us an example that punishment should not be meted out randomly. But let's change the scenario a little bit, and let's say we have 10 people who have committed the same crime under the same circumstances, and so they're very, very equivalent to each other. They're all deserving of being jailed, and there are 5 jail cells. Now, is it okay to flip coins to determine who gets imprisoned?
So the main point I would want to say about that is when we say, is it okay, I think there are different domains in which it can be okay or not okay. So it's okay as a matter of fairness. It's fair to flip coins to decide who goes into those jail cells. It may violate issues of justice. That is, it might be that people have views that everyone who deserves punishment ought to be in jail. So if your view of if you think we have a moral obligation to imprison people who deserve to be imprisoned, then there's a justice problem. If you don't think that, or if you think that it treats the people who are out in society and might be harmed by those people, that their interests are not being adequately taken into account, then it might have that problem. But if these are petty criminals who aren't going to harm anybody out there very much or at all, and if your view is, and my own view, I don't have a strong view that every wrongdoer morally ought to be punished, and if you don't have that view, then actually I don't see anything wrong with that. I think it's fair.
So the fairness then would come from the fact that everyone has a sort of, well, you have to set the experiment up just right. You have to choose 5 out of 10, but you make that choice randomly. So your idea is that it's fair because each of these people has the same probability of being incarcerated.
So I don't think it's fair because each of the people have the same probability of being incarcerated.
Okay.
So that answer would get us back to the idea of that I think it's fair because, so I think unfairness, my own view is that unfairness is certain kinds of things skewing it. So what I worry about certain skewings, not some bizarre skewing that happens. So you could have the view that what makes it fair is that you have an equal probability of getting in there, but suppose the coin had a defect and actually people don't have an equal probability or something like that, but it wasn't, you know, it's not skewing in a way that tracks other things that, you know, other groups out there. I don't think that that's a problem.
So you're saying that if the randomness maybe wasn't making things absolutely equal, but somehow who got disadvantaged by the inequality in the randomness was itself random or arbitrary, that would be okay?
Not that it was, so you want me to commit to that claim and I'm not going to commit to it. I don't think that's what makes it okay. I think what makes it okay is that it isn't one of the bad reasons, like it isn't tracking other disadvantage that we have in society. Bad luck, basically, like you just happen to have the trait that suppose it isn't a coin flip, but just like, I like the look of him, I don't really like the look of her, but it's not tracking anything that are underlying disadvantages that are already, you know, it's not reinforcing caste or compounding injustice or anything like that. It's just bad luck. Bad luck is a part of life. I don't think that that's unfairness.
Great. That sets up my next question.
Good.
So the next question is, we have a society where we need menial workers and we need people who have more rewarding kinds of work. So suppose a coin is flipped at birth to determine which of these groups you're going to belong to. So, so you've got your randomness, but you kind of changed the time. You made it at birth. And also, you've made it very pervasive. So, you know, you just happen to have this bad luck of being, you know, cast as a menial, but that's life. So how does the reasoning extend?
So the reasoning extends because now you've both raised the stakes, because a lot turns on it, or I took that was to be part of it. So one could have views about you know, what kinds of lives people are entitled to live. And I'm going to assume that even the menial laborers are treated with dignity and have a decent quality of life or something like that, right? Okay, so if they don't have a decent quality of life and aren't treated with respect, then there's a justice problem. Like there's a floor below which anybody's life should fall, and people are going to disagree about where that line is, and that's true. There's some minimum quality of life that people ought to have just because they're people. But if we're above that, and now a coin flip determines kind of what role they play in life, I actually think that that kind of is what happens, and that doesn't seem to me unfair. It's just bad luck.
The tremendous lack of self-determinism.
Right, but so
Doesn't
that,
strike-
okay, so this self-determined, so that's again, so I want to say, so that's actually the other thought I had too, sorry about that. So if you think that we each have a right grounded in autonomy to determine certain features of how our life goes, and that's certainly a view I think you and I would both share, but I just meant like, but I was taking it like, sorry, I'll just leave that. Then there is a problem in that you're not able to exercise that autonomy. What's the scope of what that should cover? I actually think that's complicated to say. Like, it's easy to say that we all have some right of autonomy that ought to cover a certain amount of scope of self-determination, but where the boundaries are, I think, are tricky to say, and I don't have any view about that. But if there's something wrong with it, with your example, it's not about unfairness, it's about that independent, non-comparative, justice-based right to autonomy.
Okay, great. So,
She's boxing me somewhere. I don't know where yet.
So what I get both from the lecture and also the response just now is that certain absolutes are being hedged. You're hedging your bets. So, for example, you talked about how sometimes there are standards for how decisions should be made. Papers on the stairs, throwing the grade papers on the stairs, or the fact that sentences should track culpability, or maybe you feel that you ought to take into account in determining incarceration the risk to the community. Or you mentioned that maybe some actors have special obligations to be accurate. So I'm wondering, sort of from a philosophical point of view, is there a common theme to these concerns? Are these, for example, maybe all questions of context, or is there some better organizing principle that we could be thinking about? Because you've essentially said that there are a lot of things that need to be taken into account, and we would like to try to get our hands on
Right.
What's in that set and what isn't.
Right. That would be great. I don't think there is a common organizing theme, but I think it's important to recognize that a lot of them are because there is an independent standard either of justice or entitlement. Not all of them are justice. You might think that I owe my students the obligation to grade their papers based on the quality of the paper because I've made a kind of promise to them that I will, or you could think that it has something to do with the norms of the profession. So some independent standard, sometimes that's about what justice requires everybody have, but sometimes not. Sometimes there are interests, very powerful interests of third parties. Those are a different kind. I think it's important, though, there isn't a common organizing theme, but I guess I would want to emphasize sometimes none of those are at stake. So if I want to have a company and I'm a private employer and I want to call my company the bum out of luck company and I'm going to hire people with the worst skills around, I can do that. Like, you know, the person with better skills doesn't have any entitlement to come work at my company. I'm going to be the bum out of luck company and hire people with the worst skills. That's perfectly fine for me to do that. So when there isn't something like these things at play, then there is no sort of entitlement to accurate classification.
Okay, so let's, we have just a couple minutes left, so let's briefly touch on the TLA. Let's take your bum out of luck example and let's actually change it for a moment to college admissions. So you might have some notion of who is and who isn't a good prospect for college, and as a college, you might choose to aim at a particular segment of the applicant pool. You may figure you're not going to get the very, very top students, you're not interested in the very, very bottom ones, but there's some middle band that you'd like to go after. And so there's some sense that having chosen your place, perhaps you should treat similarly qualified students in a similar way. And since we're really out of time, and I know one of your objections to that, let me roll that into the question, which is, schools do decide to change their, basically their position. You can have a university that manages to go after some very major funding and hire excellent faculty and just do this sort of shift. I mean, we saw that at USC, for example. So what you do in year X+1 is in some sense not necessarily related to what you do in year X, because your goals may have changed. But within a year, when you have a particular set of applicants, there's no right and wrong exactly about whom you're going to accept, but do you still think that the treating similarly is not appropriate?
I still think that treating similarly has no force in that case. So when you say within a year, why does that matter? Like, why is it within a year? You're trying to cabin the space. And to me, it seems like the only force of that I can't change, you seem to think I could change policies from year to year. In year 1, I want to go after the middle student. In year 2, I want to go after the above average student or something like that. Why can I change from year to year but not within a year? And it seems to me it must be because I announced my policy and therefore made some kind of commitment to people that I was going to do that.
What I had in mind, I'm sorry.
Well, and they're relying on it. Mm-hmm. But without that, I'm reading the applicants and I think, we were going after the middle students, but look at this student, not so good. You know what? Wouldn't it be a good idea to give opportunities to people who are at the bottom of the pack? Let's do that. Why can't I?
So one thing that that actually brings up affirmative action, which is another story, because you could have some reason for feeling that this student is deserving of special consideration, and we don't have the time to go into that. But the comparison is the competition is within a year. That's an applicant batch. And let me just finish, let me take the last word here.
I will.
With the story of the capuchin monkeys. So the story of the capuchin monkeys is an experiment. Pairs of monkeys were set up. The monkeys do tasks. They receive cucumber slices as rewards. They're happy munching their cucumber slices. But occasionally, one of the monkeys in the pair gets a grape. And so what happens? Well, the one that doesn't get the grape might in fact go ahead and do the next task, but they will reject the cucumber slice, sometimes even throwing it back. That there's this sense that they have that the grape is better and that they were just as entitled to that grape, and they're very unhappy when they don't get it. I think the treated similarly, despite your very interesting and thought-provoking arguments, touches something very deep inside us.
That was fun.
Okay, so thanks so much to both Deborah and to Cynthia. This is what I'm going to do. We'll run over 5, maybe 7 minutes. However, to do this well, I'm going to demand that these be short questions, not comments, questions. And I'm going to take them 2 at a time, and then we're going to turn back to the panel, okay? So I think, Suresh, you were first.
So, wonderful talk, and I know, I'd be happy to donate any time I have this conference to have you both talk about this some more. Great. The question I have is this, keep it short. You talked about randomness, and you talked about these notions of randomness in decision making. I would like to ask you about another aspect of randomness, right? So, a lot of us do machine learning. We're building these models. Because prediction is not causation, there is a sense in which we're trying to argue that the models we build say something about the world in a certain way that they may or may not actually say about the world as it should be or as it happens. When you talk about justice, when you talk about measuring justice, you're talking about just desserts. You're talking about some level of justice and how treatment is meted out. We use machine learning to try and make claims about the effectiveness or otherwise of delivering these desserts in decisions. How do your theories, the theories you've described about thinking about justice and fairness, how brittle are they when you start introducing this uncertainty and this predictiveness in machine learning and the way we introduce facts or sort of predicted facts into the discussion around justice? That's the question.
Okay, thank you very much. Yasin Gabriel from Deep Mind Ethics and Society. So my question is about the compounding injustice account and whether it can adequately capture cases where we create injustices that didn't exist before. For example, by focusing on previously hidden characteristics like genetic data and considerations like that. And I wonder whether, to account for these kind of new injustices that algorithms could give rise to, or social institutions, it's better to focus on a different liberal principle, which is the one that says it's unfair for some people to be made worse off than others through no fault of their own. And yeah, I'd welcome your thoughts. Thank you.
Okay.
These are for you.
Okay, so I'm going to take that one first. The question about whether it's okay for people to be harmed or made worse off through no fault of their own, whether that's the right. So to me, I want to put that in the box of justice, because now that's not, I mean, it's an appealing idea. I have different thoughts about it, but it's not about, given how A was treated, how should person B be treated? It's just, here's A, he's got this terrible disease through no fault of his own. Should that make a difference to his life? And I think, there are compelling arguments one can make about that, but it's not a fairness kind of question in the box that I'm putting that. That doesn't mean it's not an interesting question. If the question is, should things that happen to people through no fault of their own affect their lives, that's kind of a deep and interesting question that goes way beyond the kind of sorting mechanisms that we're talking about here, I guess. And if that's not adequate, I'm happy to chat with you at the break. So the brittle question, I'm not sure I thoroughly understand what the question is getting at. I mean, I'm confident I don't. But let me just say that I think I put things in a kind of stylized way in the examples that I gave to make points. And the stuff that you do, from best I can tell, and as I was saying to Solon, I would read the introduction and the conclusion and skip all the math in between, but is obviously much more nuanced and at the margins. And so taking the kind of basic claims and distinctions that I'm drawing and bringing them to bear on these much more nuanced situations, I think requires a lot of careful thought, and I'm interested in thinking about that more, but I think that there are extensions and complications that will require.
Andrew Self, Data and Society, and thank you so much for your talk. This was fantastic. The machine learning, or the, I guess, FAT community has been talking about a lot of different definitions of fairness within the technical space. We had a tutorial yesterday on 21 different definitions of fairness. Some are false positive rates, false negative rates, disparate mistreatment. One thing they almost all have in common is that they're descriptions of the outcome. And one dimension that I think you didn't talk to or speak to, and I'm wondering how much it plays into this fairness versus justice question, is procedure versus outcome. And it seems to me a lot of the decisions or a lot of the questions in the machine learning community actually just don't even speak to a lot of the legal concerns, which are much more about procedure. But I'm wondering how this, I don't understand exactly how it fits your ideas.
That's a great question. So, and I did have something to say, and if I could just say 2 minutes, like I kind of thought that one payoff of recognizing that the TLA has most bite with regard to errors is that it might favor, in the debates about different conceptions of fairness that look for parity of error rate or parity of burden versus predictive accuracy. So that was what I meant to be the payoff of that, which I didn't get to. But you're right that fair procedures is another focus. And I would say that in my panoply of the 5 theories that I put out there, the one that's about intention is actually about procedure, right? It's about inputs to the process. The one about effects is about the outputs of the process. So a lot of ways of thinking about fairness ask the question, should we focus on inputs or should we focus on outputs? I take the expressive focus, to be kind of hovering between input and output, because it's not looking at the concrete effects, it's looking at what the decision procedure, the sorting procedure expresses. And I think a deep and interesting question about when we think about discrimination is where to locate our attention. Do we care about the inputs? And in law, actually, the input is what matters most. And I personally think that's a mistake. Or do we focus on the output, or do we focus on this intermediate space about expression? And I think that's one way of really thinking about it is where do we care most? Input, output, or something in between?
So we'll do one more question. Yeah.
Me? Hi. I was wondering, Aloni Cohen, MIT. I was wondering why, this is falling.
It's on.
I was wondering why the compounding injustice, why do we restrict it to just injustice? So I was motivated by Cynthia's question about the 5 people in prison versus the menial labor dice roll at sentencing or dice roll at birth, and it seems like I can answer that question. I can draw that distinction if I also say that we have some sort of obligation to not compound the effects of bad luck, which is not injustice, as you say. Bad luck is bad luck, but if we sort of expand that just a little bit, I think it provides an adequate answer. So I wanted to get your thought on that. So
I hear you. When I first actually was working on the paper, I was articulating it as a duty to avoid compounding injustice or misfortune. So I get the intuition that makes you want to put it that way. And I wasn't convinced that there was the duty to avoid compounding misfortune, but I'm not sure about that. So I limited my argument to what I was more confident that I felt was correct, but I'm not confident that the other view is incorrect. Maybe we have a duty to avoid compounding misfortune too. When we flip the coin originally, we're starting the misfortune, I gather, rather than compounding the misfortune. But maybe once misfortunes are created through luck, we have a duty to avoid compounding them. One other great book I'd recommend to you is a book by Joey Fishkin called Bottlenecks, which talks about we should avoid having sorting procedures of various kinds that in a sense compound either injustice or misfortune, we should just avoid those different little narrow passages that stand as huge barriers to people. It's a good book that I would recommend to all of you.
So I'm sorry that we have to end, but I want to make sure people have time to have a break. Please join me in thanking Deborah and Cynthia again.
So, would have been